how you may be judged after a police use of force or after a private citizen, if you're involved in use of force, how you may be judged after the fact. And secondarily, how de-escalating a situation may not be the solution.
Well, to begin with, let's not forget that the same people that are currently prosecuting police officers and perfectly lawful officer-involved shooting incidents are also prosecuting private citizens in the lawful use of deadly force. In Ohio, there was a county prosecutor that made the statement that if officers succumb to the temptation of using deadly force, then we're going to charge them. And I've worked 4 or 5 murder cases down there where officers have been charged in perfectly lawful use of force incidents. I've also worked private citizen self-defense cases there. And so what I see amazingly is across the country, and I've testified from Iowa to Georgia now, and points in between. And I see that there's a lot of botched investigations out there by the criminal investigators, from whether it's the police department or the state police, that they bring in an outside entity or outside investigative agency. And, I wrote a book about use of force investigations years ago because I saw friends of mine that were being charged and perfectly good, or not charged, but, were the focus of a criminal investigation and improperly. So you have these poor investigations taking place. Once again, there's different standards, and the public may not know this, but in a police shooting, you have different investigations, and some of these go on concurrently, and some of them are separated. There's a criminal investigation to see whether the use of force was within the law. There is an internal investigation to see whether the policy was followed by the officer or officers. But there's also this media investigation and the public investigation. And though the media and public, unfortunately, are fueled by politics. And you have these officers, once again, and this just happened recently, where, on a case in my area, the federal judge dismissed the case on summary judgment, finding that the facts, when looking at them in a light most favorable to the plaintiff, did not support, the civil case. So he dismissed the civil case, but the media still attacks the officers. So they've already been cleared on the criminal investigation. They've already went through a civil process where the judge found that there was not sufficient evidence to warrant the continued civil case, and yet they're being attacked. And this happens very much. I mean, I worked a private citizen case, I think it wrapped up this year, in which, although the insurance company settled, it was very favorable and they were very happy, but it was on Ring doorbell and captured, where a subject arrived at a family's home. He hadn't been there or hadn't seen the young girl, his former girlfriend, for a couple of years, and he forces his way into the front door, even though he's told to leave and told that the homeowner had a gun. Homeowner shoots and kills him. And you couldn't believe what the expert witness for the plaintiffs was alleging. If only they had opened up the door, then all this would have gone away. And he even made an opinion that was contrary to the evidence. And that's what people like myself deal with all the time. So you talk about the standards. Oftentimes what they want to forget are the legal standards and focus in on things like officer-created jeopardy. And the same thing with a private citizen. If the citizen had just chose to not answer their front door, had chose to retreat into their house and pick up the phone and call 911, and all these shoulda, woulda, coulda standards, and that's not the legal standards, So we have that part of it, and what the plaintiffs, and I don't work a lot of civil cases. Most of my cases are criminal. So what the prosecutors oftentimes are doing are trying to come up with these hindsight-based officer-created jeopardy things, that the officer, if he, and the standard one is taken more time and created distance, and it never would have happened. Well, it's irrelevant because, we're not judging him on what he could have, would have, should have done. In Ohio, we have a case called State v. White that says specifically not to do that. But even Ohio prosecutors are ignoring it. And then you talk about de-escalation, once again, time and distance. But see, the problem is that policy like de-escalation for an agency, even private sector with citizens, de-escalation is not a law. In other words, you don't have to attempt something. If deadly force is called for and at the moment, then you don't have to attempt these other forms of less lethal control. And you got a case out there, it's called Placas versus Drinsky, which talks about that. Guy came at the officer with the fireplace poker, and the big allegation was back at the day is that he should have pepper sprayed him. Well, judges said, no, the question is was force at the moment reasonable, within a range of reasonableness? And once again, reasonableness is not precise. It can't precisely be defined, or we can't use it like a graphic, like use of force continuum. So I think I got both of them. But, once again, they're going after officers and private citizens because of that pre-incident behavior.